Hello, you've made it to the last module. Well done, that's quite an achievement. And this module, it's another slightly tricky one, I'm afraid, is on changing and in particular harmonising terms and conditions after a TUPE transfer. Now, the natural consequence of a TUPE transfer is that the transferee ends up with a combined workforce on two sets of terms and conditions. Sometimes the employer just wants to get everyone onto the same employment terms without making any changes in the workforce, such as redundancies or a change in location, but it's not that easy. And in this module, you're going to learn about the default position, you'll learn about when an employer can make changes, and I'll talk about the best way to vary terms and conditions. The normal legal position for changing contractual terms is that an employer can do so if the contract allows the change, such as a mobility clause, or the employee agrees to the change. But the position is different after a TUPE transfer. Even if the employee agrees to post-transfer changes, that agreement and the changes are void under Regulation 4 of TUPE if either the sole or principal reason for the change is the transfer, which is typically just harmonisation, or if the change is for a reason connected with the transfer that is not an economic, technical or organisational reason entailing changes in the workforce. If a change is void, it'll have no legal effect. If an employer simply wants to harmonise terms and conditions after a TUPE transfer, the sole or principal reason for the change will be the transfer, so the changes are void. And the same is true if changes are made pre-transfer with a view to harmonising terms for those who are going to transfer. Now, this significantly limits what an employer can do to address its two-tier workforce. And it's tempting to think the passage of time will stop the changes being linked back to the transfer. Well, good luck with that. Employers can be tempted to wait it out for a period of time and then make changes, hoping employees won't make the connection. And it's fair to say the longer the gap, the more likely it is that other events will occur, which can be used as the intervening event as the principal cause for the changes, rather than the transfer being the principal cause. But proceed with caution. Tribunals are really sceptical about this. In a case called Taylor and Connex Southeastern, the Employment Appeal Tribunal found that an employee's rejection of new contractual terms was connected to a transfer from 2 years previously. Harmonisation of terms for harmonisation's sake will always be likely to be linked back to the transfer, however much time has passed. So when can an employer make changes? Well, despite the default position, there are some situations where an employer can make changes to terms and conditions after a TUPE transfer. First of all, changes for other reasons that aren't the TUPE transfer. Sounds obvious, but a change which has nothing to do with the transfer is allowed, subject to the normal rules about making contractual changes. And I have another video course on changing terms and conditions, which deals with this at length. Sometimes the reason for changing terms isn't the transfer, but some other event which happens to arise, I don't know why I did air quotes then, which happens to arise around the same time as the transfer. So if a business suddenly loses a major client, and any changes relate to that loss of the client and not the transfer, then the changes won't be void. The same may apply if an anomaly is picked up during the TUPE process. I'll explain what I mean. I'm thinking of a case here called Tabbera and Mears. And in that case, at the time of the TUPE due diligence, the employer discovered that an outdated travel allowance was still being paid. It was some ridiculous travel allowance that had existed many, many years, if not decades before, and just through oversight was continuing to be paid. And it removed the allowance because it was outdated and unjustified. The courts held that the reason for the removal of the allowance, the change of terms and conditions, wasn't because of the transfer, it was because the allowance was outdated and unjustified. So because it wasn't because of the transfer, the change was valid and not void under TUPE. Then there's an economic, technical or organisational reason entailing changes in the workplace. We looked at ETO reasons in Module 8 in relation to dismissals, and the same principle applies to changing terms and conditions. Changes to employment terms are allowed if they're for an ETO reason, such as a change in numbers or a change in functions of employees. And the parties have to agree to the change, of course. If an employer is simply looking to standardise terms across the workforce, it's unlikely to meet the ETO test because it won't entail changes in the workforce, in the job functions and the numbers of employees. If it doesn't meet that test, the change is void. So again, that means an employer's ability to harmonise terms is very restricted. I get asked several times a year by clients, come on, we've got to be able to harmonise them somehow. How can we do it? And the answer is, well, usually you can't. TUPE says you can't. Therefore, you can't. It's that simple. To be fair, some situations do fit the bill better than others. So changes in the workforce can include a change in location. So if an employee wants to move if an employer wants to move a transferred employee's new location, and the employee agrees to that in preference to being made redundant, then that change is allowed as long as they both agree to it. There's an ETO reason, and the change in location provides the necessary change in the workforce. So there's changes unrelated to the transfer, changes for an ETO reason, entailing changes in the workforce, and third of all, changes that the contract allows. Now, sometimes the contract has the right to make changes within it. For example, a mobility clause which a transferee may use to vary a transferring employee's contract after the transfer. Theoretically, that change isn't void under TUPE if it's a change that the contract already allows. But remember, back to Module 8, that Regulation 4.9 allows an employee to resign and claim unfair dismissal if there's a substantial change in working conditions to their material detriment. And for that claim, the relevant change doesn't have to be a breach of contract. So, as an employer, you've got to exercise caution even if the contract seems to allow for such a change. What about changing terms that were incorporated in a collective agreement or from a collective agreement? Well, Regulation 4, Subregulation 5b of TUPE, 4.5b, allows a transferee to make changes to an employee's terms which stem from a collective agreement after a year has passed since the transfer. First year, no changes. After the first year, you can make changes. But the terms overall have to be no less favourable than the employee's previous terms. If the changes are made to the terms derived from collective agreements within a year, or overall they are less favourable, then the changes are void. What no less favourable means isn't clear, so this issue might well end up in court at some point being decided in the future. What about insolvency? Now, the rules around changing terms and conditions, basically saying you can't, are relaxed when the transferor is subject to insolvency proceedings. Now, this is to encourage the preservation and survival of businesses, and for that reason, liquidation isn't included, because liquidation is about winding up and closing the business rather than preserving the business and helping it survive. So if the business is insolvent, other than for liquidation, contracts can be varied even if the reason is the transfer or connected with a transfer and not an ETO reason, provided it's designed to save the business and preserve employment opportunities. Now, what about changes which benefit the employee? Are they void? Guidance from the government department, B is Business, Energy and Industrial Strategy, says that changes which are entirely positive and which are agreed by the employee and not prevented by TUPE are unlikely to be challenged anyway. Yeah, I know, obvious, isn't it? There can be a double recovery danger, though, for employers who vary terms in this way. Because what if an employer agrees some new, more favourable terms with an employee, potentially in exchange for some less favourable terms? Well, TUPE still operates to protect the employee's original terms which transferred across, and the normal rules of contract law means the transferee cannot wriggle out of the more favourable terms which it's agreed with the employee directly, and this leaves the employee in a position to cherry-pick whichever pre- and post-transfer terms are the most beneficial to them. So care has to be taken to make sure the employer doesn't end up disappointed in both the terms and in the pocket. What about harmonising restrictive covenants or changing restrictive covenants? This can be really thorny in TUPE situations because although the restrictive covenant terms transfer like any other, they transfer as drafted with the terms enforceable by the transferee protecting the transferor and its business interests, not protecting the transferee. And that's a bit useless, especially if it's a retendering situation and they're competitors. So they're useless. Restrictive covenants, once a TUPE transfer has taken place, are effectively useless because there's no longer any employment relationship between employee and transferor, and the business interests that need protecting are those which are now the transferees. So this leaves the transferee exposed. A transferee cannot force key staff to agree fresh restrictive covenants after a transfer. Any change the transferee imposes, or indeed that are agreed simply to harmonise covenant terms between new and existing staff, avoid, because it's by reason of the transfer. Even if the employer can show the variation is simply connected to the transfer, finding an ETO reason is going to be tricky. In cases where fresh covenants are accompanied by significant financial incentives, courts have still found that the covenants were not enforceable, even if the overall contractual arrangement was beneficial to the employee. But despite these difficulties, as it happens, it's very rare, but some employment contracts do have clauses which require an employee to agree to similar restrictive covenants with the transferee if there's a TUPE transfer. Whether it's enforceable or not, whether there's consideration for that, who knows? It's a contractual punt that the employer takes in the hope that the employee won't object. Sometimes the practical solution may not be legally enforceable and may come at a cost, a negotiated price or a litigated penalty. So careful judgments required here, and almost certainly some legal advice. Most employers won't just impose new terms on employees, because that potentially creates a breach of contract from which a constructive dismissal claim can spring. Dismissing an employee and re-engaging them on new terms after the transfer creates an effective dismissal from the old terms and is also therefore automatically unfair. An employment tribunal can order compensation, and it can order reinstatement to the old terms, rendering the whole process pointless and potentially very costly. So the safest way to effect change is by using a settlement agreement. Now, an employer can't use a settlement agreement to agree a change to contract terms, because any contract change made by reason of TUPE is void, other than in the circumstances I've described. But a settlement agreement can be used in a dismissal and re-engagement situation to settle the automatic unfair dismissal claim. The new terms offered in that situation isn't a variation of contract, which would be void, but a fresh contract following a dismissal. Now, this is sound in theory. The principle hasn't been fully tested yet in courts, so you do need to exercise a little caution and possibly seek legal advice, but I think that approach would work. What's the upshot? Well, due to the technical difficulties associated with harmonising terms, even years after a TUPE transfer, employers should do their homework before the transfer about the employment terms they're inheriting. Well before the transfer, employers should plan how to deal with any practical difficulties which flow from having a two-tier workforce and decide how best to approach the issue with staff. Changes which are void or create a legal claim can be costly in many ways. Now, business transfers can be stressful for everyone. Inheriting employees who already feel aggrieved isn't good for business. So using your best human resources managers throughout the process and ensuring the procedures you follow are open and honest and supportive of transferring staff are crucial. the loyalty and the commitment of employees is likely to be worth an awful lot more to the business than a few pounds in the pay bill. And thank you for watching. Well done. You've completed Module 10. You're all the way through this course. It's quite an achievement if you've watched the whole thing, because it takes time and it's complicated and you need to think, and you've probably been making quite extensive notes. So really well done. You deserve to feel proud of yourself for getting all of this done. If you do need help, do have a look at my website, please. www.danielbarnett.co.uk. You'll find information about me. You'll find that there are lots of things you can download there. There's a free email update for case law that comes out 2 or 3 times a week. There's a podcast that you can subscribe to, which comes out every single week. And there's a whole ton of other resources. www.danielbarnett.co.uk. Thank you so much for watching. Bye-bye.